My Lord and my Lady, I, together with Mr. Rose, who appeared in the Court of Appeal Criminal Division and the court below, the Chelmsford Crown Court, appear for the appellant. Mark Richard Golds and Mr. Perry and Mr. Little appear for the respondent. Very briefly, this is an appeal from the Court of Appeal Criminal Division on 2 points of law certified by that court of being of general public importance, relating to the operation of Section 2.1 of the Homicide Act 1957, as amended by Section 52 of the Coroners and Justice Act 2009, and arising out of a conviction for murder sustained by the appellant at the Chelmsford Crown Court, His Honour Judge Ball, Queen's Counsel and a jury, on June the 11th, 2013, for which he was sentenced to life imprisonment with a minimum term of 15 years to serve. His trial arose out of the stabbing to death of his partner, Claire Parish, at her home on Sunday, July the 15th, 2012, following an argument at and after a family barbecue. The court is aware of the severity of the attack upon her in front of her children.
Horrendous, yeah.
His defence was that although he killed her, satisfying the conditions necessary for the crime of murder, he should be relieved of his liability for that crime and found guilty instead of the crime of manslaughter by operation of the partial defence of diminished responsibility under the two aforementioned acts, which defence was principally supported by the opinion and evidence of two consultant psychiatrists. His appeal to the Court of Appeal Criminal Division in March and May 2014 was unsuccessful, but that court granted him leave to the Supreme Court to seek the opinion of this court on two questions. Those are set out at page 38 of the case for the appellant.
Thank you.
I'm sure the court is familiar with them, but if I may just set the scene, read them. Where a defendant being tried for murder, question 1, seeks to establish that he's not guilty of murder by reason of diminished responsibility, is the court required to direct the jury as to the definition of the word substantial, as in the phrase substantially impaired, found in section 2.1b of the Homicide Act 1957 as amended. Second question, if the answer to the first question is in the affirmative, or if for some other reason the judge chooses to direct the jury on the meaning of the word substantial, is it to be defined as something more than merely trivial, or alternatively in a way that connotes more than this, such as something whilst short of total impairment that is nevertheless significant and appreciable? The trial judge, as the court will appreciate, consistent with previous authority, declined to define the phrase substantial impairment for the jury at all, unless and until the jury sought his further assistance, which this jury did not.
Yes.
The way I think the learned judge put it was if they encountered a stumbling block, then they could return and he could give them certain limited assistance, which the court can no doubt glean from the authorities, the nature of that assistance and what it would have been. In our argument, we begin with the dictionary definitions of the word and the meaning of the adjective substantial. And we have placed in the bundle the dictionary definitions there.
We're very grateful to both you and your team, as it were, and Mr. Perry and his team, for the written arguments, which are very clear and not assumptive.
I hope we haven't committed, certainly on our side, the opposite sin of being underrepresenting the points. But
at the moment, it doesn't seem that you have, but thank you for asking.
Thank you, my Lord. And we submit at volume 1, page 318,
yes,
there are three potential definitions of the word substantial, which we set out essentially in two broad categories. And those are the one that perhaps, and I say, quite frankly, Mr. Rose and I have road tested without any scientific method at all, but on all friends, colleagues and associates, the various definitions. Number one features very largely in people's responses. and that is the one that denotes considerable importance, size, or worth. The second concerns the essentials of something, and the third, real and tangible rather than imaginary. And we submit essentially one is in one category, the other two, which relate to the essence of the thing, are in 2 and 3. Now, in the Court of Appeal ascribed the word narrow to the real and tangible definition, which is expressed in the more than minimal formulation, and wide to the important weighty one. Because we found early on there was a difference of opinion when people were talking about the subject. Some people put it the opposite way round. I have simply plumped, if I may use that expression, for the Court of Appeal's designation, simply to avoid confusion. So when they are referring to narrow, I'm referring to narrow in the same way. It can easily be argued it, in fact, is the other way around.
You're saying for today, you propose that narrow has the real or tangible meaning,
Yes.
and
Yes.
wide has the
Yes.
large meaning.
I tried it the other way, and it simply became confusing when I was discussing that case.
Provided we all have the same
Thank you.
dictionary, lexicon, that seems fine.
Well, can I just ask you about that third meaning? It doesn't seem to me to be to do with minimal or trivial or something of that kind.
No.
It's what it says. It's a contrast between something which is real and something which is imaginary.
I think, my Lord, the reason for that is that when one is actually looking at that definition, if one then wanted to put that into a formulation that expressed the view that something was real as opposed to not real, that is where more than minimal would come in. In other words, if it genuinely exists as opposed to being fanciful, far-fetched.
Well, speaking for myself, the example that came to mind of usage in the third sense was the poem, the glories of our crown and state are shadows, not substantial things. And the sense in which you say a ghost was insubstantial.
Yes. Yes, my Lord, respectfully, we agree with that, because in fact, when one looks at the word insubstantial, that, contrary to the word substantial in ordinary usage, may tend more towards the narrow meaning when one's looking at it in the negative. But it may be that in any event, it is important when the word is being used to understand that although it may have meanings, different meanings, they are relevant to the context in which the word is being used. So in ordinary speech, though it may sometimes be confusing, the use of the word will generally be understood by the other party. There are some hard examples, such as a substantial point in your argument, which if it covers 3 pages may well be the first definition. But if it means the essence and sense and reality of your argument, the key point may be in 2 and 3. But certainly differences between ethereal and substantial, in the sense your Lordship just mentioned to me, or alternatively a substantial breakfast in the classic use, which in fact the Court of Appeal itself is, I think, the example it uses, plainly would be applying to the first example of considerable size, worth, importance. And may I say, running through everything that is said is the fact that one can't escape in the 1957 Act unamended the words being governed, that is, in effect, mental responsibility, are the words to which the substantial impairment obviously is applying.
But it is a different question, isn't it?
Yes.
The question of whether somebody's mental functioning is substantially impaired is a different question from whether their responsibility for what they have done is significantly impaired.
My lady, we agree.
I thought you would.
It's with respect, it is entirely the point, because where one is dealing with responsibility, one quickly is introducing an ethical concept to the word. And indeed, coming to the end of what I will be saying on this particular section, it is that really in the 1957 Act, that section applied, giving the jury a decision as to whether this defence should apply to that defendant, looking at his culpability and not looking at a test that can be more scientifically defined, as it is in the 2009 amendment. So in a sense, although the word substantial is used and is transferred over, in the amendment, the context of the word in our submission is different. The impairment in the 2009 Act, of course, is the impairment of an ability or capability to do one of the three things that are set out. And so we submit there's no necessary reason why the approach to the word should be the same as it was to the 1957 Act. It may be, and indeed it is suggested that the word hasn't changed its meaning in Ramchurn, although Ramchurn was, of course, dealing with the 1957 Act. But it certainly, we would submit, doesn't necessarily follow that that would be the case when one examines the context of it.
In the end, we're concerned with what the 2009 Act means, and it may be looking to see what other predecessor acts which were differently expressed means is merely going to complicate the issue, not assist.
Yes, I mean, we have prepared, as one can see in the argument, to, and as I think the respondent has too, to look through the authorities from Simcox. But it may be that in the light of what your Lordship says, I can deal with that relatively briefly, in fact.
Well, others may have a different view,
Yes.
but it seems to be often that it merely complicates. Parliament has reenacted the concept in different words, but happens to use one word that's the same.
Yes.
I have some doubt as to how much assistance one gets from looking at cases on the earlier statute, unless they give some guidance in terms of general policy.
Yes. There is an additional difficulty, frankly, with some of the earlier authorities as to really wondering whether the weight that they bear, particularly Simcox, is justified by the extent of material that we have in the authority.
I can understand that.
Particularly is in a number of the early authorities, they were dealing with an issue where the experts were not opining on the question of whether there was substantial impairment favourably to the appellant.
Yes.
And were in fact saying that it was no more than moderate. So in fact, they were not designating it. However they were coming to that conclusion, they were not designating it as substantial at all. And so it's in the context of that that the court is looking at the definition. If one, in fact, I don't think I need to take you to Byrne, which is the first of the line, because it seems that Simcox is more significant and dealt with the problem in a rather different way. And
Byrne is, you may be right, and
yes.
by all means try and persuade us of that, but
Yeah.
Byrne is the decision which, if you look back over 25 years of Archbold, you will find has appeared year after year after year, up to and including 2008,
yes,
as the principal starting point.
yes. Well, I'm not submitting that it obviously starts the line of authorities, my lord, that culminate in effectively in Ramchurn. It's interesting that in the argument in Byrne, page 358,
Yeah.
counsel for the appellant says, and we submit with force, at the final full paragraph on page 358, with regard to the wording of section 2.1, substantial means something considerable, that would be the wider meaning. One has to consider whether the accused's mind was materially affected at the time of the offence, which tend towards the narrow meaning, and it's partly a question of right and wrong, and partly a question of moral responsibility. Lord Parker, at page 364, makes clear that, 7 or 8 lines from the bottom, inability to exercise willpower to control physical acts, provided it's due to abnormality of mind, is sufficient to entitle the accused to benefit of the section. Difficulty in controlling his physical acts, depending on the degree of difficulty, may be. And it's for the jury to decide whether that is reached or not, and whether the difficulty is so great as to amount, in their view, to a substantial impairment of the accused's mental responsibility for his act. So it certainly sets out the framework to which the cases subsequently attend. Simcox, we have put in 2 reports of that. One is the Times Law Report at page 366, and one is at page, the Criminal Law Review is at page 367 and 368. And it appears, because the word moderate, unless I've missed it in the other report, which is quite possible, but the word moderate features in the Times Law Report, in the second column, just above halfway down the page, talking of the experts, that effectively not one would go to the length to say that he was suffering from substantial impairments, which certainly, as case law has developed and practice in the courts has developed, would seem to be quite a difficulty that one would be facing, particularly if, as has occurred increasingly over the years, the experts have opined on the issue of substantial impairment, even within the 1957 Act. And so, moderate degree, harder for him to control his actions. Not one of the experts felt they could say substantially. And so the court could see no grounds for criticising the way the judge dealt with the word substantially. And then perhaps the key part of the description in that Simcox, it was a matter for the jury to approach in a broad, common-sense way, taking into account not only the medical evidence, but the man's history and conduct and the whole circumstances. And that is the blend we would submit of the part that may be said to be within the potential province of the scientist and the part which is a matter for the jury, considering the case as a whole. And there's a distinction we would submit to be drawn between the jury considering it in the round, but from a medical standpoint. In other words, do they agree with the experts? And then what we submit actually is plain in the 1957 Act is occurring, an area reserved for the jury alone, which is the question of whether they will give the appellant, or the defendant in that case, the benefit of this particular defence. The report at 368, in dealing with what was held, is more expansive as to what the court said. There's no scientific test. There is no statutory test, again emphasising the matter in a broad common sense way, and then makes this observation: the last sentence of the direction would not of itself been a sufficient direction on the question of self-control. That last sentence appears to be we do not think it was something which really made any great difference, although it may have made it harder to control himself, refrain from crime, then you would find him guilty as charged. If I may then, because these are perhaps the three key early authorities, look briefly with the court at Lloyd. Lloyd, again, in an area of law that's rather bedeviled with curiosity, Lloyd is used, and we submit correctly, to draw a distinction between two different approaches, what might call the Lloyd approach and the Simcox approach. But in fact, it wasn't a distinction apparent to the court in Lloyd at all, because Justice Edmund Davis is going out of his way to affirm Simcox as being the law. Now, the difference between the Lloyd formulation, which is neither merely trivial, nor total at the other end, but somewhere in between, is distinguished by commentators with Simcox, being that it is more in the sense than moderate plus, and approached in simply a broad, common-sense way. At page 371, Michael Davis, when he was in Silk, representing the appellant, puts the argument far more succinctly than I'm putting it at the moment, which is that substantially could mean one of two things: real and not illusory, or of considerable amount.
Narrow or wide.
Narrow or wide. The judge should have assisted the jury by helping them as to its meaning. He should have directed them it meant real or not trivial. So, my lord, that is perhaps where that elision occurs. There was no question of the meaning being superfluous. It really meant that the impairment was more than trivial. Now, that is, in fact, expressly rejected by the court. It's rehearsed by Mr. Justice Edmund Davis on page 373. And the point he makes, which is echoed by Lord Judge as Lord Chief Justice in Ramchurn, is the question of whether the word substantial would be redundant in that context. And that is what Justice Edmund Davis said in respect of Michael Davis, Queen's Counsel's argument. We submit that isn't correct, that it wouldn't be redundant, because there is always a distinction to be drawn between something which is fanciful, but which you may still describe as an impairment, but an impairment of no consequence, and an impairment that has some consequence, some tangible element to it. And so we submit the word is not necessarily redundant, and indeed you will see, and I accept before I make this next comment, that one must approach when this word is used in other contexts with caution in other areas of law, but we put in the Equality Act where the word substantial is actually defined with the meaning we contend for in this case. And it is in the context of substantial impairment. Now, there are many different considerations that apply to the Equality Act, and there may be all sorts of reasons why that is true that don't apply to this case. But nevertheless, it does mean that it isn't, by definition, a superfluous word when put together with impairment. In Lloyd at 374, having rehearsed the argument, Mr. Justice Edmund Davis said, "This court is wholly unable to accept that submission. Word is inserted with a view to carrying some meaning. It does carry a meaning, and the court was unable to see that the direction given to the jury on the meaning of the word could be criticised, and finds itself in a difficulty of saying that any distinction that can be validly drawn between the direction in Lloyd and Simcox is not, as it were. Of course the words are not identical, but the substance of the direction in both the instant case and that of Simcox seems to be to this court indistinguishable the one from the other." My Lord, those are in a sense the three starting authorities on which attention is still, as my Lord, Lord Hughes actually makes clear, is still the basis and bedrock of the law as it developed. There was in the 1980s, and I know the court will have read it, and I'm not going to take the court through in any detail, but there was a rather damning series of articles, or an address to a symposium for forensic psychiatrists, and a subsequent article by Professor Grew, where he was somewhat, well, that's an understatement, he was very critical of the language used by Parliament, and indeed expressed the view that what appear to be attempts by the court to be helpful are really not helpful and are not solving the essential problem of what the meaning of the word is. And he explains the reason for that is the combining a potential medical element with a potential moral or ethico-legal element. And those two things together, he says, mean, as he unpacks it, to use his phrase, mean that it effectively is coming down to a jury decision as to whether this ought to apply to this particular defendant they're dealing with.
Yep.
And actually gives two examples of where you may have a defense for which the jury has some sympathy because of the circumstances, and therefore the amount of abnormality found and the degree of impairment maybe at the lower end, and which is a danger we submit in cases, crimes which a jury might find naturally and understandably horrific, where the test will be applied at a much higher level. And it was in the context not relevant because, in fact, the reform that took place in 2009 took account, no doubt, of the criticisms that were made of the formulation for reform in the 1980s. It was making the point that had the reforms, in his view, been carried out in the 1980s, the position would have actually got worse rather than better, which is always one of the dangers when one tries to reform something that appears not to be working very well. May I just turn briefly to Egan, which develops a theme really that on occasions in the authorities, it is clear that the court may interchange both formulations, the Lloyd formulation and the more than merely trivial formulation, not always appearing to see that it is done that. In the headnote to Egan at page 376, and I, of course, remind myself that this was a case that was involving the effect of intoxication. That was its particular subject matter. Halfway down what is held, the accused would have killed, as he in fact did, if he'd not been drunk, and whether he would have been under diminished responsibility, that is more than a trivial degree of impairment of mental responsibility. However, one doesn't have to go more than a few lines down to the per curiam to see that's not quite what in fact the court is now saying, because in directing on the jury the issue of whether there was substantial impairment of mental responsibility, the jury should be directed that they either approach the word substantial in a broad common sense way, or that substantial means more than some trivial degree of impairment, which does not make any appreciable difference to a person's ability to control himself, but less than total impairment. Now,
And is that founded on the parting shot, the last sentence of the judge, of Lord Justice Watkins' judgment?
yes,
Or is
my Lord,
it
it seems to
elsewhere
be,
as well?
because if we go to...
Well, also, I think his summary of the effect of Lloyd, because the appreciable difference comes in at page 382, letter H.
yes,
Now, that wasn't a phrase which had been used in Lloyd,
no,
but that's how Lloyd was interpreted by the Court of Appeal in this case.
my Lord, yes. And indeed, that then leads to the final sentence, 386, which read in context with 382, says that for the avoidance of doubt, we advise judges that guidance as to the meaning of substantial should be explicitly provided for the jury by using one or other of the two meanings in Lloyd. And it does seem that this theme of there being two meanings in Lloyd carries through a number of the authorities. There is then perhaps a different approach. If I take the court to page 419,
Yeah.
and this is the case of Mitchell, perhaps more important for Professor Smith's commentary than what one might actually glean from the what is held in terms we can all hear being expressed. Professor Smith says it's a welcome departure from the current trend requiring the jury to be directed what their common sense would naturally lead them to do anyway. The case, as the court will remember, was about the order in which the ingredients were dealt with, and said it made no difference. And over the page, saying that it was having declined to that it was necessary for the judge to direct the jury about the meaning of the word substantially using one of the meanings of the two meanings in Lloyd, he goes on to say definitively, substantially does not have two meanings, and the two passages do no more than tell the jury in more words that substantially means substantially. They should be able to work that out for themselves. It may be, of course, that in that commentary, which is somewhat against me, I accept, that commentary may in fact be referring by not having two meanings in the sense understood in Lloyd, rather than not a bold statement that the word substantially is not capable of having two meanings or different nuances of meaning, but simply saying...
You say when it's used in a particular statute or contract or conversation, it has one meaning. Taken out of context, it can have a number of meanings, but it can only have one meaning in a particular sentence.
Yes, and the task obviously is to decide what in that particular area it means.
Can we just go back to Egan for one moment?
Yes.
The court interpreted Lloyd as saying that the word meant more than some trivial degree of impairment which doesn't make any appreciable difference to a person's ability, etc.
Yes.
That appears to me to be saying that it is both necessary and sufficient that it should have made some appreciable difference.
Yes.
Would you accept that whatever the relevance of this may be to the construction of the 2009 amendments,
Yes.
that had come to be a settled understanding by the time of the 2009 Act.
Yes.
Yes, thank you.
One of the things preparing this case produces as an effect is that the questioning of almost every word one comes across, and of course appreciable is another one of those words. But I do accept the force of what the...
It certainly is what a practitioner would have found if he'd gone to 2008 edition of Archbold.
Yes, yes, absolutely.
Yep.
So, if I may then come to Ramchurn, perhaps say to the court that Mr. Rose, in fact, was junior counsel for the prosecution in that case, so remembers it very well. This was really inquiring where there were several directions given by the judge, including one in particular because he did have a question, extremely experienced judge at Ipswich Crown Court, because he had a question from the jury asking for further help. And in the head note, Lord Chief Justice says it was necessary for the judge to convey to the jury the plain meaning of the statute, no more, no less.
Can you give me a...
I'm so sorry, lady, 49.
Thank you.
Yeah.
It's necessary for the judge to convey to the jury the plain meaning of the statute, no more, no less, provided he doesn't exaggerate the burden of the defendant or improvise some extra statutory additional obligation. In the instance case, the judge's first direction accurately conveyed the issue to be addressed by the jury, and with the jury requiring further elucidation of the concept of substantial in the context of impairment, mere repetition of the earlier decision would not have helped. Consequently, the judge rephrased what he had said. In doing so, he didn't in any way alter or add to the burden the defendant was required to discharge. And since there was no uncertainty either as to the statutory language or the directions given by the judge, the conviction was safe. Now, this confidence that the court had, and maybe correctly had, in Ramchurn was not shared by the Court of Appeal in Goals. They didn't positively say that the court was wrong, but they respectfully questioned whether that in fact was the position.
We just look at the two directions.
Yes.
You're coming to them, are you?
I was coming to the directions, yes.
Then, of course.
But perhaps before that, the difficulty sometimes this argument provides is set out on page 432, actually in what occurred in the courtroom by way of questioning. Mr. Glenn, Queen's Counsel, obviously with one interpretation in mind, said in the long exchange, last question, you agree with me, do you not, that the part that it played was more than trivial?
And then in re-examination.
More than trivial in re-examination. Mr. Peters, so certainly doughty opponents, Mr. Peters, Queen Counsel, said, didn't substantially impair his responsibility for the actions of killing. I'm already said in my view is that it didn't. So exposing sometimes the gulf that occurs. And indeed, one of the points we make later on in our case is that the difficulty with this particular phrase, and unlike words like dishonesty, which are used in criminal trials regularly without any great difficulty, is it's not just the jury that has to have some idea of what is being meant by the words. The experts, particularly now in the respect of the 2009 Act, are encouraged to opine on the subject. Counsel, on both sides, have to make a determination of what it means in order to advise their own sides.
Yes.
And the judge himself has to make take a view before the summing up. And so if we're all operating on different bases, that's not helpful.
Percy.
I suspect what the page that's now more relevant, page 433, dealing with actually the explanations.
What he said, what the
he
judge said. Judge DeVay said, yeah.
The first two paragraphs in which he's defining the difference between the use of word A and the has no significance in our submission. It's the same, in effect. Substantially impaired means just that. You must conclude the abnormality of mind was A, or the real cause of the defendant's conduct. The defendant does not need to prove that his condition was the sole cause, but he must show that it was more than a merely trivial one, which didn't make any real or appreciable difference to his ability to control himself, therefore confirming that the approach, the use of the word appreciable, was still in good currency in 2010, in fact, has continued on, because this case, of course, was still under the old Act. Then the question comes from the jury.
Yep.
In legal terms, can you advise the difference between trivial and substantial? The defence say that of substance equals substantial. Is that correct? Was one of the questions one dreads when sitting, because they get rather to the heart of the matter. The following direction has been approved at a senior level, and it is this: the direction on the word substantially impaired. Your own common sense will tell you what it means. Substantial does not mean total. That is to say, the mental responsibility need not be totally impaired, destroyed altogether. The other end of the scale, not trivial or minimal. It's something in between, and Parliament has left it to you to say on the evidence, was the mental responsibility impaired, and if so, was it substantially impaired? And we submit that again illustrates the difficulty that judges had with the 1957 Act.
We haven't quite finished the quotation because it continues over the page.
I'm so sorry, my Lord. The word substantial means more than some trivial degree of impairment, which does not make any appreciable difference to a person's ability to control himself, but it means less than total impairment.
That's really a repetition.
It is repetition in those three lines. It is possible to read in our submission that elucidation to the jury of being a little closer to the somewhere in the middle line, which you, the jury, decide upon in your common sense judgment, than the earlier definition given when he was giving the original directions, save for the use and understanding of the word appreciable. Now, it's key in Ramchurn that the Lord Chief Justice says that there is very little difference, page 435, paragraph 21. There's very little difference between the issues canvassed in Lloyd and the way Judge DeVoe dealt with the matter. And at 437, paragraph 27, his first direction in the summing up accurately conveyed the issue to be addressed to the jury. And the court was clear that anything said subsequently did not make any difference of worth. That was the matter that the Court of Appeal in Goals was begging at least to consider in its...
But in the judge's directions here, on all three occasions, he talks about either real or appreciable, or
Yes.
either uses the phrase any real or appreciable difference, and in the last occasion, simply appreciable.
Yes. And that is very, very close to Lloyd.
Yep.
And interestingly, looking at this with the hindsight afforded by the formulation in the 2009 Act, am I right that we can see that in his first direction he was concentrating on the cause?
Yes.
And in the second, he was concentrating on the effect on the ability to control himself.
Yes.
Which didn't need to be distinguished, of course, then.
But does, and one see now, does need to be, yes. And then finally, and perhaps to be approached with a degree of caution because it's a sentencing authority, the case of Brown.
Yep.
And at page 440,
Yep.
well over halfway down the page, just after the words Homicide Act 1957, Section 2.
The court was invited.
Yes.
Yes.
The court was invited to consider whether the words provided a different test to that which was applied to the term substantial impairment in the Homicide Act. So now this is one of the few authorities that's actually dealing with the position after the 2009 Act.
After it was amended or before?
So after the amendment, as I understand it. And of course, importantly, it's the Lord Chief Justice again, who had been dealing with the issue in Ramchurn, but under the old Act then. When Parliament enacted the 2009 Act, it was aware of the way in which the court had interpreted the phrase substantial impairment for many years. The jury had been directed, that is in Brown, that substantially impaired required the jury to conclude that the impairment was more than minimal. Accordingly, the sentencing judge was entitled to reach the conclusion that the appellant's responsibility for the death of his wife, although diminished, remained substantial in the wider sense, one would presume, and that he retained real culpability for what he had done. Now, this is often held up by commentators as an example, first of all, of the use of the two different strands of meaning, but also, and possibly not as fairly, as an implication that the judge was necessarily approving of the trial judge's formulation. In fact, he doesn't say one way or the other. He merely says that is what the trial judge said.
Didn't matter, did it?
And it didn't matter because it's a sentencing report, so I don't think I can fairly...
He'd been acquitted of murder, after all.
Yes, yes. So comment on that maybe, as I say, a little...
Nonetheless, it is an authority on this Act.
That is its, yes, that is certainly its particular feature.
Thank you.
The other examples, which, unless the court particularly would wish me to, I'm not going to take the court through, but are dealt with in paragraphs 20 to 39 of our argument, really deal with varying uses of the word substantial in its narrow and wider formulation. And I hope fairly we've tried to include examples both sides of the line. And as the court has already observed, they are contextual, so that the use in the Equality Act is different from the use in a sentencing guideline, but it simply means that the word is capable of bearing both strands of meaning.
Understand.
Or perhaps, as in the 1957 Act, lands up somewhere in the middle. The 1957 Act, we submit, the reason why it is never actually defined by the court is that it is not an assessment of a definable impairment, because it conveys, at least in part, a value judgment, which is exclusively for the jury. And I confess to not being the person who introduced Professor Grew's materials to the bundle, but I was very grateful to my learned friends that they did, because it was an illuminating experience reading his analysis. Particularly, the two articles begin at pages 604 and 608 of volume 2, for those using the written materials. I'm sorry, they don't begin at 604. The page I refer to is 604.
Thank you.
In the page 20, in the first paragraph, which is where the professor unpacks what he says is really the meaning of Section 57 insofar as one can discern it. He says, packing it together, I'll come to his final conclusion rather than go through all the forms of it. The defendant's abnormality of mind is of such consequence in the context
sorry, where are you?
I'm so sorry, page 604,
Thank you.
It's about 12 lines down.
I think it helps to unpack them before you read them.
Right, yes, very well. He says that if you force the compacted ideas, that is in fact the Act, you get something like this. He had an abnormality of mind of appropriate origin. This had a substantial adverse effect upon one or more relevant functions or capacities of perception, judgment, feeling, control. So that's if I just myself interpolated that point. That seems to be dealing with what might potentially be the scientific, the area upon which the psychiatrist can comment. In the context of the case, this justifies the view that culpability is substantially reduced. Now that, in fact, is plainly dealing with the area, province of the jury, their moral judgment. But in fact, as we know under the 1957 Act, it was common for the psychiatrist simply to give an opinion that a person came within the Act, so would be including both elements. And as Professor Grew says, the attempts to reform in the 1980s would have exposed this more clearly and in fact made expert opinion redundant and indeed impermissible by law, because it would have been going to the ultimate issue, which was not ultimately an issue of science at all. So I'm sorry, my lady, I now come to where I presumptuously started. The outcome is diminished liability, manslaughter. Now he says, pack that together in a different form. His abnormality of mind is of such consequence in the context of this offence that his legal liability for it ought to be reduced. And indeed, in the version, as he says, of the Majesty's Council of Judges advising the Butler Committee out of court, the defendant has shown recognisably abnormal mental symptoms, and in all the circumstances it would not be right to regard his act as murder in the ordinary sense. So it's open to the jury to bring in a verdict of manslaughter.
This is the wording that on the previous page he describes as altogether a disgrace.
I'm afraid so, yes. Yes.
Well, sort of language that Professor Grew used to use,
Actually,
with some reason.
is his disgrace a reference to the wording of the 1957 Act?
Yes,
Yeah.
Yes, not to the submission to the Butler Committee.
definitely not.
No.
He did have some observations on the submissions, and the Butler Committee
Yes, he did.
really saying they may get more than they bargained for, in effect, if this reform goes through, may not quite achieve what's wanted. And it is, again, where he's again being very direct, in the penultimate paragraph on the same page, elsewhere he says the judges occasionally speak as though they're being helpful, but without managing to help very much. In Lloyd, for example, the Court of Appeal approved Mr. Justice Ashworth's direction on substantially. Substantial does not mean total, that is to say, the mental responsibility need not be totally impaired, etc. At the other end of the scale, substantial does not mean trivial or minimal. There is no sign, though, that the learned judge gave any suggestion to the jury of what this mental responsibility was, of which trivial, impairment, total, or permanent, so to speak, or something in between might be found. He gives a series of explanations, some of which the court may find both likely and indeed compelling, as to why the court may have permitted psychiatrists to give opinion on this particular issue, notwithstanding the combination of a scientific and a ethico-legal element, being that in fact it was, wrapping it up in a nutshell, that it was more convenient to the court for that, because the psychiatrists knew what they were talking about, and it was a way of not leaving the thing simply in the hands of the jury, without the jury being given some guidance, even if the guidance might have included guidance as to a matter that the psychiatrist was not expert in. The section, which I'm not going to read out, but halfway down the second column, which begins after Walton 13 in brackets, and begins, it seems that the jury may set the defendant's abnormality against the character of the offence. That is the section I referred to earlier, which deals with how you may get widely varying outcomes under this particular test. And if the court wishes to follow through, but again, for the purposes of my argument, not necessary, in the subsequent pages 21 and 22, that is his explanation, or the series of explanations he gives as to why psychiatrists were permitted to express their opinion. Indeed, he says, I will read out just one short paragraph, having said I won't, in column 2 of page 605, the penultimate paragraph, he says, first, not all judges have understood that Section 2 raises an ethico-legal rather than a clinical issue, and some judges, I believe, still do not. A High Court judge for whom I have the greatest respect recently asked me, in effect, who could say whether responsibility was substantially impaired if a psychiatrist could not? To which, presumably, Professor Grew, if he'd answered, would have said the jury, because it's their decision.
Yep.
Lord, may I then turn to reform? and to what happened in 2009. I can deal with this relatively briefly because the court is familiar, for a number of reasons, with the Act of 2009 and the history of it and how it came to be that it was passed by Parliament, largely including the recommendations of the Law Commission, except for the ones concerning, from memory at any rate, developmental immaturity, which Parliament was not prepared to deal with, certainly at that stage. And immediately looking at the language of the Act, one can see the difference between that and 1957, because the substantial impairment is to do something rather than in respect of a mental responsibility. The three things are set out. The abnormality of...
Well, you're very kindly talking about it all, but you haven't actually referred us to where we might most conveniently find it.
I'm sorry.
In paragraph 2 of the judgment of Lord Justice.
I know, that's where I've got it. But,
Yeah.
Or in fact...
Should we look at it in the, as it were, the Queen's printer's copy?
We actually printed the Act, so it's there at page 309 if it's...
Thank you. Yep, thank you.
And setting out that the person who kills or is a party to a killing is not to be convicted if he's suffering abnormality of mental functioning, arose from a recognised medical condition. B, crucially, substantially impaired D's ability to do one or more things mentioned in subsection 1A. Those three things being the understanding of the nature of his own conduct, forming a rational judgment, and exercising self-control. Now, it has been said, perhaps with some force, that 1 and 2, A and B, are getting very close to the hinterland of insanity under the Macnaghten rules, and that quite often the issue will come down to C, the ability to exercise self-control.
But when looking at this, it is very important that we don't overlook paragraph 2.1c2, isn't it?
2.1c, yes.
Because
I'm so sorry, yes, I did.
Before, I mean, the concerns which led to the reform of the Act were that the old test presented a rather muddled mixture of the medical and the moral.
Yes.
And there was a deliberate attempt to make clear what was the role of the psychiatrist and try to align the defence more closely to medical concepts on which psychiatrists could properly assist the court. And so the question of causation, which had been rolled up along with impairment in the old formula, is separated here.
Yes.
And you've got these two complementary aspects, but I don't think one can perhaps safely construe one looking at only half the picture.
Yes. So 1C, saying that the abnormality of mental functioning provides an explanation for D's acts and omissions in doing or being a party to the killing. And at 1C, specifically in respect of exercising self-control, an abnormality of mental functioning provides an explanation for D's conduct if it causes or is a significant contributory factor in causing D to carry out that conduct.
I don't quite understand why you're concentrating so much on C.
A loss of control.
Yes. Now, obviously, it was a new feature in the law
Yes.
in 1957 to introduce impaired ability to control one's self into the consequences of mental disorder on liability, criminal liability. That was a new thing, and that was basically what Byrne was all about, that it was included. But the other two features are just as likely to arise, if not more likely to arise, from a recognised medical condition affecting your mental functioning, even though they come nowhere near the severity of the Macnaghten rules insanity. So I think it'd be unfortunate if we approach this question thinking only in terms of the lack of self-control, because many people are not sympathetic to that.
No.
as an excuse. You know, I could not control myself because of a personality disorder. Many people will think, well, that's a pretty poor kind of reason for saying that you shouldn't take responsibility for what you actually did. Very different if it's somebody who doesn't understand what he's doing, or has an impaired ability to understand, or even more, has an impaired ability to make choices, which is not the same. So I don't think we should be looking at it just...
Well, as a matter of construction, I was just slightly puzzled by your suggestion that Section 2(1) capital B, which is what we can loosely call the causation
Yes.
test, is linked only to self-control. It's very confusing, but surely when it says for the purposes of subsection 1C, that's a reference back to 1C, not 1A.
Yes, it is.
C.
Yes.
Absolutely.
Isn't it?
Yeah.
Yes.
So it's all of them.
So that's part of why I was saying what I was saying. It's all
It
three
in fact
of them.
features to a certain extent in this case because, my memory serves me right, Dr. Latham actually found...
Well, there was a bit of a difference between the two psychiatrists, wasn't there?
Yes.
Because one was definitely saying that he did suffer from a psychotic illness, which...
Dr. Stamps.
Yes, which did include delusions.
Yes.
Whereas Dr. Latham was, I think, less clear about that.
I don't think Dr. Latham disputed that he did suffer from delusions. I think he did...
But his diagnosis was different.
His diagnosis was in the area of personality disorder, although he did describe it in his report as a severe abnormality.
Yeah.
And my
Yes,
memory...
he said both, didn't he? Personality disorder and delusional psychosis.
Yes. And he, again, if my memory serves me correctly, his in fact was finding all three at 1A to have been met. I'm sorry, my learned junior reminds me that it's Dr. Stamps who found all three to be met.
Yes, it was Dr. Stamp. Yeah.
Yep.
It's my memory, I'm afraid.
Yeah, Latham, I think, was B and C.
Yes. The Act has obviously attracted a considerable amount of academic interest. We put in Professor Ormerod's judicial studies literature in which he deals with his understanding of it, and my learned friend, we hope that you have that, put in some additional paper authority today, which was Frederick Smith and Hogan and Ashworth.
Yes.
And forgive me being not having it at my fingertips because I received it in hard copy form relatively recently. But anxious, of course, particularly to explain what the differences might well be. It's set out in the hard copy, if the court has it, of Smith and Hogan at page 612.
Yep. No.
Oh, I'm so sorry. I didn't appreciate that. No, it's just going.
Is that 612 an internal page in Smith and Hogan?
That's 612 internal pages of Smith and Hogan.
Page 11 of the thought. Thank you very much. Yeah.
Thank you, Mr. Little. Thank you, Dad. Yep, 611. Sorry,
612.
Right. Lord Tilson hasn't got it yet. Sorry. Thank you.
There's a helpful review of the case law under the old law, and also in the first paragraph under 3, a
Substantial
synopsis in
impairment,
effect
yep.
of what the change has been.
Thank you.
And Ramchurn is dealt with at page 613, in which the learned editors of Smith and Hogan submit that Lord Judge's evaluation of the law in Ramchurn is correct. And says, halfway down the page, its meaning is somewhere on a spectrum between less than total impairment and more than minimal. And then, in fact, comes to consider the case with which the court is concerned at the bottom of the page, and there is, again, a helpful and useful synopsis of the issues in gold. Culminating at page 614 with the opinion of the editors that, as a result of Golds, there now exists a conflict in the case law. Now, they, unfortunately, it's not a criticism because I think it may be the better way to look at it, they use the language the other way around. So they're talking about Golds being restrictive, but that's the wider that I'm referring to.
Sure.
So in Golds, the court took a more restrictive approach, although some of the language implies that the court may have thought it was adopting a wider approach. I'm going to leave that one. The approach that had prevailed for decades meant that the meaning of substantially lay somewhere between more than minimal impairment and total impairment, and it was for the jury to conclude where. Gold suggests that an impairment that is more than minimal will no longer suffice. The law now imposes a higher threshold. The practical consequence is that it makes it more difficult for defendants to plead diminished responsibility successfully. Goes on to say the judgment in Golds raises a number of issues and with respect might have been clearer. It's not clear whether Parliament intended for the meaning of the term substantially to be altered. As Lord Judge observed in Ramchurn, Parliament presumably invoked the term knowing how it had been applied under the 1957 Act. That may be somewhat overconfident, but it's at least Parliament didn't do anything to suggest that it did not hold the same interpretation. Whether it considered it at all is another matter. In the absence of any evidence to the contrary, it submitted that Lord Judge was correct to conclude that the term ought to be interpreted in the same way under the 2009 Act as it had been under 1957. And indeed goes on to say, really the point I made at the beginning, there is, whether there's in fact a conflict between Lloyd and Simcox is questionable. Finally, the court expresses unease that different judges may be ascribing different interpretations to substantial, but that issue will remain unresolved given that Golds holds that judges ordinarily should not give a direction to juries as to how they ought to define substantially. It is submitted that the approach that ought to be adopted is the one set out by Lord Judge in Ramchurn. The judge should direct the jury whether Dee's ability to do one of the three things listed was substantially impaired is a matter for them, paying close attention to the expert evidence and that the term encompasses an impairment that is more than trivial. Interestingly, my learned friend has also, and I hope, has that come with the same bundle? Yes. With the same bundle, has also put in, from the latest edition of Ashworth, his views on the same subject, or the editor's views on the same subject.
Professor Horder, isn't it?
Yes.
Yeah.
Which is not quite the same as that in Smith and Hogan. It's an interpretation.
Well, it's quite hard to get a precise reconciliation between their acknowledgement that the question of impairment and the question of the substance of the impairment is really one on which medics can give an expert opinion,
Yes.
While preserving it as a jury question as to
Yes.
what the facts are.
Yes.
It's quite difficult to reconcile in a way, although one understands this goes on all the time.
It is, my lady, and it's perhaps particularly difficult where the experts are in agreement and the matter is left for the jury. Perhaps easier when the experts in the traditional adversarial way are arguing two different positions of science, which the jury, as in any issue of expert evidence, are entitled to reach a decision about. But of course, in this case, And in some cases, the experts may be agreed that it is substantial impairment, and the jury is being asked to consider whether that in fact is correct. And that may be something, if I may, I'll approach a little more in Brennan, which deals specifically with this issue of either uncontested or barely contested scientific evidence, certainly uncontested by other scientists.
One might suggest, putting it in the simplest possible terms, the broad purpose of the amended section is to afford a partial defence to a defendant who was suffering from an abnormality of mind which impacted on his ability to do the various things listed, and which was a significant causative factor in his conduct. As a broad proposition, would you agree to or dissent from that?
I would agree with that.
And going then to what might almost be seen as the unnecessary additional word, substantially, but to see how it fits into context, you've agreed that the accepted understanding of the word in a different context before the Act was that it required something which made a real or appreciable difference. Can you think of a case where the abnormality of mind made no real or appreciable difference to the defendant's ability to do the various things listed in 1A, but yet was a significant contributing factor in causing him to act as he did?
No, I can't.
No. Thank you.
Somewhere I have a memory that it was postulated that there could be such a case, but I don't think the author went into details as to what that might be, and I'm afraid
No, well, I mean, I've been
struggling
struggling to think of them, but conscious that there may be ideas that you haven't thought about, which is why I've asked the question.
Yes.
Well, what about the kind of case where a man's mental illness or mental impairment is such that he does have difficulty in forming a rational judgment or exercising self-control, but it's rather like the example that the judge gave to this particular jury. On this particular occasion, he'd embarked on a perfectly straightforward robbery.
Yes.
He had no interest in anything other than money, and he'd planned it, so it wasn't a case of loss of self-control. Now, what about that?
Well, that fails at the second.
It was precisely so.
I think, as I understood the question, it's a question of whether you could have it the other way around.
Oh, I beg your pardon.
Precisely so. Because that, yes, I mean, clearly the Act does not provide defence to somebody who may suffer from a quite serious mental abnormality, but that is simply not the cause of what he did.
Yes.
Right.
Yes. Ashworth, if the court has that easily accessible in the hard copy form, is at page 279 in its internal pagination.
Yeah.
And both of these textbooks are now edited by people who are or have been law commissioners.
Yeah.
I'm sorry to say, we I think, agree that there is a difference between their approaches.
Yes. Oh, yes.
Perhaps that goes with
Professor
Would not
Ormrod,
be the first time.
Professor Ormrod, I think, doesn't have bare responsibility for the amended form of the Act. He came to the Commission after that had gone through.
Yes, that is right. At page 279, the editor is talking about the two scales and says clearly substantial doesn't mean complete, for otherwise there'd be too much overlap with the defence of insanity and scant justification for a conviction of manslaughter. At the other end of the scale, substantial impairment may mean simply more than trivial or insignificant. That was the view taken under the old law in Simcox. This approach has now been endorsed as the right one under the new law in Goals. Now that, with respect, is the issue with which I think we all four take some issue, because we do not read Goals to be saying that it is simply the more than trivial or significant. Indeed, the very opposite. goes on to say, although unhelpfully the court suggested a judge could rightly refuse to comment on the meaning of the term at all in a direction to the jury, that is unhelpful because it's quite likely that a jury will apply a more stringent test of substantial impairment if the jury is revolted by what the defendant has done. They should at least be told that this is not an appropriate way to approach the issue, even if behind closed doors they end up adopting it. So we would respectfully agree with the second part, but the suggestion that Goals means what it is said to mean there, we would submit is in error. May I then now turn to Goals itself, which is in volume 1, page 319.
Yep.
The head note and the substance of the judgment have some subtle differences in the sense that we submit when the court is actually explaining how the more detailed explanation would be given to the jury, it is clear, we submit, that it is pushing towards a wider definition in its terms than the one that has been traditionally and previously adopted by the courts. Now, in the head note, it says the word substantially as amended did not have the narrow meaning of more than trivially or minimally, which seems to dispose of, with respect of the observation I just read out, but had a wider meaning which requires juries to determine its meaning by applying common sense in the range from trivial or minimal to total. That could be said to be perfectly consistent with Lloyd, that a trial judge should properly refuse to give an explanation of substantially, but that if any explanation were given in response to a jury's request for help, it should be in terms stating that it meant an impairment which went beyond something that, although it might have made it harder for the defendant to control himself and to refrain from crime, did not really make any great difference, and that accordingly the judge had erred, etc.
Had not erred.
Had not erred.
Yep.
When one, in fact, then comes to the more detailed discussion,
Yes.
having reviewed the authorities, the court says this at page 330. Paragraph B. At the heart of this submission is the contention that the word substantial is capable of having two different meanings. One possible meaning is that the abnormality of mental functioning substantially impairs if it does so to a more than trivial or minimal extent. It then has substance and the impairment is substantial. The narrow meaning. A second meaning is that the abnormality of mental functioning only substantially impairs, whilst not wholly impairing the defendant's ability to do the thing specified, it significantly or appreciably impairs that ability beyond something that is merely more than trivial or minimal. And perhaps the example is illustrative of what was in the court's mind. For example, if a salary is described as substantial, that would not convey the meaning that it's something a little more than minimal. On the contrary, it suggests that it is significantly more than that. Further on, at page 333, paragraph 71,
Thank you.
we're concerned if the position is as we believe it might be, different judges are in fact directing juries in different ways with respect to this important principle. If the substantial test is met, once something more than trivial or minimal is shown, that is very different from a test which requires the jury to determine its meaning by applying their common sense in the range from trivial or minimal to total. No doubt the concept must derive its meaning from its context, but there is at least a respectable case for saying that Parliament may have intended that any material impairment would be substantial if it has substance, that is more than trivial, and this ought to be sufficient to reduce the offence from murder to manslaughter. The extent of the impairment thereafter would be relevant only to sentence. However, for reasons we have given, we do not think it states the law, and then effectively what is reproduced in the headnote follows.
Thank you.
We also submit, as the commentators have mentioned, that it is somewhat peculiar to say that no direction should be given, or curious perhaps is a better word, to say that no direction should be given on the meaning of the word substantially, unless the jury ask a question. Then if they ask a question, you're going to give them the wider definition in the term of Golds. That would mean really the chance of whether a jury happened to ask the question would influence what in fact they are going to be told and what test they might be applying.
I mean, there's a risk they'll apply the wrong test because nobody has told them what the right test is.
Yes, it's really exemplified in the judge's summing up when he says if you encounter a stumbling block, well, they may not have encountered a stumbling block. They might just have applied the test in its often used form, meaning definition 1 in our list, in effect. We accept, as I think was clear in the court, that if the definition that, had it been given, would have been necessarily the wider one envisaged in Golds, then no injustice could in fact have followed from the failure to give it for obvious reasons, because that's the worst case scenario, if I may use a slightly vulgar expression. And so we submit that the answer to the first certified question in respect of whether a direction to the jury should be given is yes, and the second certified question is something more than merely trivial or a variation on that formulation, the narrow definition. And I might add, if not that, not at all, the wider definition that we submit has been given by Golds' secondary position. I wonder if I might turn briefly to the case of Brennan. The court will appreciate that as far as our case was concerned, that the ship had sailed by the time Brennan came before the Court of Appeal.
Yes.
And therefore we read it with interest and were something of a dilemma as to how we then dealt with it in relation to this appeal.
Yes.
Through the kind consent of the respondent.
Yes.
They had raised no objection to us putting it before you.
Yes.
Quite what can be done, if anything needs to be done, is perhaps a more difficult issue. Brennan also, however, is helpful on the question of the new Act and how it applies, because Lord Justice Davis gave very careful consideration to what the changes were made and was effectively describing, we would submit a sea change that occurred in the law from 2009 and the implications of that.
Yep.
Brennan again is in volume 1.
Yes. Tab 6 at 335.
335.
Yep.
Now, at first sight, and indeed, I think this really is the position of the respondent, at first sight it seems to be stating uncontroversial principles, that where there is no evidence of the commission of the crime, even though it's the defendant that bears the burden on the balance, using the principles, not in the Scottish case, but the other case of Galbraith, the English case of Galbraith, you remove it under normal principles. Now, in fact, subsequently, further on in the judgment, Lord Justice Davis deals with the issue of what happens when there is some evidence. I may say at paragraph 346H, he gives a helpful 4-stage test as to the application of the new law. But for our purposes, the key passages are at 352, when he's dealing with withdrawal from the jury. This was an odd case, and it's odd for two reasons. One, in fact, as I think we made clear in our argument, by pure coincidence, it is the same court, the same judge, and the same prosecutor as in the case the court is considering. And it also had this feature that there was, in this case, one psychiatrist who gave evidence, but the prosecution did not rely on the psychiatrist that they had commissioned, although that psychiatrist was not called by the defendant. And rather boldly, but in character with her, Ms. Forshaw raised this point for the first time in the Court of Appeal, that the matter should have been withdrawn from the jury. And certainly, because obviously Mr. Rose has had some anxious moments, it seems to us that the law was, before then, that even where experts were in agreement, it was ultimately a matter for the jury whether they accepted their evidence or not. That was a sort of classic statement of the position. Now, in withdrawal from the jury at 352, talking about uncontradicted evidence for the defence and no other evidence rebutting diminished responsibility, that the murder ought to be withdrawn from the jury. Goes on to say, we certainly would agree that where that is the scenario, then murder should be withdrawn from the jury, and that perhaps isn't controversial. But with respect, we're not inclined to agree with the tentative suggestion that withdrawal should be confined solely to that scenario. That, in our view, would be too prescriptive. What if there is some other evidence? That other evidence, which no doubt will comprehend the other facts and circumstances referred to in various of the authorities, must we think the evidence which looked at in the round is at least capable of rebutting the defence? To say that, we think, is not to permit an otherwise impermissible judicial encroachment on the proper functions of the jury, nor unduly to encroach on the burden of proof placed on the defence. It's to acknowledge that there may be cases where the other evidence is, for example, too tenuous or taken at its highest to permit a rational rejection of the defence of diminished responsibility. The court goes on to say also that in cases where that other evidence is capable in effect of expert opinion, the prosecution should seek, preferably, an expert to put that position before the jury. In Brennan, the court will have noticed there was other evidence. In fact, one of the other matters I was thinking about late into the night is to what case would there be where there was no other evidence. There are probably rather unlikely cases. There will always be something that could be relied upon to suggest that, for instance, particularly, and bearing in mind what the court has already said, but particularly in relation to loss of control, that in fact it isn't made out. And in this particular case, as we can see, loss of control is certainly how the judge placed it before the jury. And as far as the evidence is concerned in Brennan, there was plainly other evidence. First of all, planning, detailed planning. Second, what I might call coming within the heading of cunning, so that his attempt afterwards to clean himself up and sanitize at least himself, and theft from the deceased. On top of that, he faced an adverse inference from the court, or for the jury at least to consider the possibility of making an adverse inference, for his failure to give evidence. Now, in Gold's case, the matter relied upon is previous violence, admitted in the case of his previous partner, and also, although in a somewhat unsatisfactory state because he did not give evidence, some suggestions that he had assaulted the deceased on the day in question, where she had a mark on her face, and there is some evidence that the court will have noticed to that effect. And so it is said, well, that evidence of lack of control is a matter upon which the jury would be entitled to disagree with the experts, as it were.
That's not how the judge dealt with it, is it? He dealt with it on the basis that it was evidence of control.
Yes. Yes. In Gold's...
And secondly, sorry, I do beg your pardon for interrupting, and firstly, evidence of untruthfulness.
Yes.
Which went to, or might have gone, I suppose, to the question of whether the jury approached this case on the basis that he was, as I think Dr. Latham put it, in the grip of a psychotic, I'm sorry, the way the judge put it, in the grip of a psychotic episode at the time of the offence, or not.
Yes.
That would make all the difference, one might think,
yes,
to the outcome.
And he was cross-examined upon that, Dr. Latham.
Yes, he was.
I don't think Dr. Stamps was in Mr. Rose's recollection, but...
that's how the judge dealt with it.
And the judge deals with that in first of all, in pages 143, the general point at D, the doctors make it quite plain they don't rely on any particular single answer. That, I'm sorry, is in the core volume of using the papers. They look at every answer, so it's page 230.
Yep.
They look at every answer that is given critically, and even if there had been a history of violence, their diagnosis would not differ. And the judge, again, emphasising the point just made, page 231, says that during other occasions he did not inflict major injury that made it apparent to all and sundry that he was assaulting her viciously. And so it may be, it's a matter, again, entirely for you, that would provide some support for the fact that despite his mental illness, he's able to exercise self-control at moments of stress and at moments when violence is continuing. Again, and the judge is extremely balanced in the way he deals with it, again, to put it in context, the doctors say yes, but the past was different. The past, from what we understand it to be, was the levels of stress were less, the build-up must have been different, because there are no signs in the past if violence was used. It was used on the occasion when in the middle of a psychotic episode, where we're satisfied on this occasion he was in the grip of a psychotic episode, which means that different considerations apply. So the issue was left to the jury, fairly balancing both sides. But the question with respect we pose really is this. The court in Brennan says, well, if the experts have themselves considered the point that is being made, then in a sense the point becomes part of the uncontradicted expert evidence. Because that's the only authority, which is no doubt why the court is suggesting where the prosecution has an issue like this, it is better to call expert evidence of its own to say, no, this would make a difference. Because the jury, in effect, are left with taking away the fact that if he exercised control on a previous occasion, this explanation either is faulty to the doctors, or in fact he could have exercised control on this occasion. And that is a matter which, as far as expert evidence is concerned, they're not assisted by anything except the expert saying we've taken it fully into account and we do not accept that it makes any difference to the diagnosis, which includes being able to opine on the issue of whether this appellant falls within the description of the test for diminished responsibility under the 2009 Act.
We're getting rather away from the certified question.
Sorry about that.
Aren't we getting a little bit away from the certified question?
Yes. We're getting away from it even by my introduction of the topic, I accept. But that is why we put in the note saying that Brennan has happened. We're raising it with the court to the extent that we can.
What are you asking us to do about it?
Well, I'm not sure, really.
Right.
It's there for our edification.
I think it may be that if the court feels able to express an opinion on the issues raised in Brennan, but it can't, at the moment, we are, I'm probably not allowed to use it anymore, the expression, I think the court is functus officio as far as the Court of Appeal Criminal Division is concerned because of the timing of the matters. But in any event, I have raised it in those terms which is within the argument. I don't think I can really take it very much further than that.
Thank you very much.
And all those are the submissions I make on behalf of the appellant.
Could I just ask us for a little bit of clarification on the last argument?
Yes.
The court in Brennan accepted that deciding whether to describe something as substantial or not involved evaluation,
Yes.
which was indicative of it being a jury issue.
Yes.
I can see that that where the expert witnesses have given their evidence, if the judge considers that in light of the evidence as a whole, there is simply no rational basis on which a jury could evaluate the impairment as being substantial, then he would be entitled to take the issue away from the jury.
Yes.
That's I think, a slightly subtler formulation than simply saying that if the experts all agree that the impairment is substantial, then the jury would be bound to accept their evaluation.
Yes.
You would accept that? Thank you.
I suspect we can't, I speak only for myself, but I suspect we really can't get very far into Brennan. But if and to the extent that anybody asks us to, one of the things that occurred to me about this case was that it was quite impossible to get out of the summing up what it was that counsel for the Crown was asking the jury to do.
Yes.
Now, you weren't there.
No.
And indeed, I think there's only one person here, at the bar at least,
Yes.
who was.
Well, I wonder if Mr. Rose may follow me to deal with that.
Well,
Oh, not in Brennan, I'm sorry, no. Your Lordship was saying in Brennan, not or in Gold?
no, in this case,
Gold.
in Golds. If only, I mean, it may be that we don't get to it in any event.
Yes.
It may be that it's best left on that basis. But certainly, I'm right, aren't I, that you simply can't tell from the summing up
No.
what was being said. It occurred to me that one of the issues might have been, and it's pure guesswork, whether there was a psychotic episode.
Whether there was a...
Psychotic episode,
Yes.
particularly given it'll be self-defence. But I don't know.
I can assist you to this extent, I think, and
Yes.
Mr. Rose can, if necessary, assist probably in more detail. If one looks at the opening of the case, diminished responsibility is dealt with, because I remember this vividly when I read it. Diminished responsibility is dealt with by saying you may hear something about something called diminished responsibility in this case. It has no application in the submission of the prosecution. And Mr. Rose tells me, although I don't get this from the opening, that in fact it was really being put by the prosecution on the basis that this is an angry man.
But by then, forgive me,
The
by then the plea on the basis of diminished had been tendered. It was the only issue, wasn't it?
yes,
I see. Well, no, this is in the opening you're talking about, before the evidence was given. But by the time counsel gets up to open this case, he must have known, one, that the only issue was diminished, and two, that the two experts were going to be called.
yes. One of whom was, of course, his original.
Never mind their provenance. But he must have known those things. Yes, I see. All right. Well, thank you very much.
Well, whether, and I should be fair, of course, if that's what the written opening said, how it actually was opened. Was it opened in that way? Oh, yes, I'm told it was opened in that way by those.
Yes, but it's the closing that perhaps mattered. Oh, all right. Thank you very much. That's all I can ask.
That's another matter.
Thank you very much indeed, Mr. Etherington. Rose, in light of what Lord Hughes has said, I don't know if you want to tell us very briefly, in case it becomes relevant. If it needs further elaboration in due course, we may ask you for a bit more, but I think just some idea, very briefly, would help us.
Of course. If I can take my lords and my lady to page 256 of the core volume.
Thank you.
This is the way His Honour Judge Paul Queen's counsel leaves it ultimately with the jury in introduction to his summary of the evidence given by the experts.
Yes.
Yeah.
About which we make no complaint.
Yes.
From reading in, of course you're permitted to do so because, as I say, it's your task, not theirs, to determine the result in this case. But if you were to disregard the opinion of those three experts, there would have to be some logical basis for doing so. Mr. Jackson has put arguments before you which you could, if you chose, employ to question their opinions and the validity of their opinions. And if at the end of the day you find there is a logical and sound reason within the context of the case as a whole to disregard their united opinion, you may do so. But common sense and fairness might dictate that you would be slow to do so, but you are free to do so should you consider it to be just and fair. Now, my lords and my lady, that begs the question, what were the arguments that the prosecution were placing before the jury? And doing the best I can, for Mr. Etherington has referred to the angry man, and that would be the label, so to speak, we would place on it. With respect, I think we would submit that there is a discernible difference in emphasis within the learned judge's summing up, which was the promotion of an alternative theory, which Lord Hughes has already referred to, namely, were the earlier episodes of violence indicative that this was a man who was, in fact, capable of exercising self-control. That was a proposal advanced in the summing up more enthusiastically by the judge than it had been by the Crown. Right. Can I assist at this stage any further?
That's a very helpful summary. Thank you very much indeed, Mr. Rose. Mr. Perry.
Yeah, may it please the Court. My Lords, my Lady, we support the conclusion reached by the Court of Appeal, namely that the appellant's conviction for the offence of murder is safe, but we have a number of observations to make in relation to the court's reasoning. The first observation is this, that before the decision of the Court of Appeal in this case, there was no apparent or perceived problem with the adjective substantial or the adverb substantially, at least not so far as Section 2 of the Homicide Act is concerned. The orthodox view reflected in the academic writings and also the standard practitioner works, and also in the standard judicial directions, was that an impairment was substantial if it was something more than minimal or trivial, and it certainly did not need to be total or amount to borderline insanity. The case law also recognised that it was a question of degree, and that whether or not the partial defence was made out was a matter for the judgment of the jury, having regard to all the evidence in the case, not just the expert evidence. My Lords and my Lady, we will be submitting that there is no reason, in answer to the President's observation towards the outset of this argument, there is no policy reason discernible in the materials that came into existence before the amendments to the 1957 Act. There is no policy reason discernible as to why the question of substantial impairment should have changed. The same phrase is used, and as the materials before the court make clear, this was one of the few matters that the academics didn't criticise, and it's certainly something that the Law Commission didn't criticise on the many occasions that it looked at the operation of this section. And interestingly, when Lord Roger considered this matter, or when the full bench considered this matter, speaking through Lord Roger, he referred to diminished responsibility operating where there was a substantial impairment. The Scottish Law Commission adopted what Lord Roger had said in the decision in Galbraith and said it was obvious what that meant, without any need for elucidation. I'll take the court through that in a moment.
Thank you.
The second observation that we would make is that the case law was in fact clear. This is an observation that Lord Justice Elias himself acknowledges or makes at paragraph 72 of the Court of Appeal judgment, see volume 1, divider 5 at MS
Well,
page
he says
70.
it was clear but contradictory, or ambiguous.
Well,
Clearly ambiguous.
he says it's clear, but we would submit that it had been authoritatively stated that there was no difference in substance between the directions given to the jury by Mr. Justice Finnemore in Singpox.
Could you just give us the citation again, please?
This is page 333, is it?
It's volume 1, divider 5, page 72.
Paragraph 72.
Paragraph 72.
Yeah, page 333, yeah.
Sorry. Yes, paragraph 72.
But a minute, I thought you began your submissions by saying that the orthodox view was that substantial meant more than merely trivial.
Yes.
Well, that's precisely not what Lord Justice Elias says the jurisprudence establishes.
Yes, and I'm saying that analysis is surprising, because we would submit that the case law was clear the other way, as I'll seek, I hope, to demonstrate. And the third point that we would make is that the case law had proceeded on the basis that the jury should not be required to engage in the sort of semantic debates that are not helpful in the context of criminal proceedings. Part of the problem that arises in this sort of area is the search for synonyms to use as surrogates or substitutes for what is an ordinary English word, which has to be considered in context by the jury and against the background of the issue in any particular case where the partial defence arises as to whether it's murder or manslaughter. The point that we make is that according to the earlier case law, the spectrum of possibility was from more than minimal or trivial at one end to something less than total at the other.
Yes.
But on the basis of the Court of Appeal's judgment, the spectrum of possibility has now been narrowed, if I may use narrow in this context. The spectrum of possibility has been narrowed from something significant or appreciable to something less than total. But we would submit that this merely shows the danger of replacing the statutory wording with some other describing word, because one very important matter we would submit is how is this intended to work in practice? And it might be argued that significant and appreciable are themselves ambiguous describing words. Yeah. But what happens if the jury come back to court and say to the judge, you've told us it's got to be significant or appreciable. We think it's more than minimal, and it had some effect, but what does appreciable mean in this context? We then get into trying to define the substitute of the word that Parliament included within the Act. And it is also, we would submit, it is also perfectly reasonable to contend that significant or appreciable simply mean more than minimal.
Word trivial could also be said to be not a precise word. How trivial is trivial?
Yes. Yes.
Now, in Lloyd, they appear, on one possible reading, to be contrasting, and I think this is how Lord Justice Watkins read it, contrasting the minor or trivial with the real or appreciable. But another possibility is that there is some sort of terrain in between the trivial and the real. That depends on, I suppose, what you mean by trivial and what you mean by real, but it's very difficult to identify that terrain with any clarity.
Well, Lord, this we would submit is the difficulty with respect with the Court of Appeal judgment, because at the moment, before the Court of Appeal judgment, you had a spectrum from more than minimal to something less than total. Now the spectrum has been reduced to something beyond the minimal or trivial, that no man's land where it doesn't operate before you engage the defence by something that is significant or appreciable. And the point I'm making in terms of workability is, what do you do when the jury say, where does the no man's land end and where does it begin? And you've told us it must be significant or appreciable. The statute says substantially impaired. Is there a difference between significant and appreciable? How do they fit in with the possibilities? We would submit are potentially endless. It's rather like Bertrand Russell's question as to when a man with thinning hair actually becomes bald, or when is a breakfast substantial? Does it remain substantial if you take away a number of the ingredients? These are not the sort of semantic debates that will really assist in the proper administration of justice on such important and significant questions.
So what does it mean? Anything identifiable?
Or do you have to say that it's substantially enough to satisfy the test of substantiality in the subsection? It's, in other words, completely circular.
Well, Lord, the only satisfactory way, and it's operated for over 50 years. The only satisfactory way of doing it is if the jury ask for assistance, is to give the direction that was based on the decision in Lloyd, which was the approved Judicial Studies Board direction, which was the more than merely trivial.
Well, it wasn't, you see, with great respect. The more than merely trivial was, as it were, a bookend.
Yes.
After which you said to the jury, but you must be sure it was you must be satisfied on the balance of probabilities that it's substantial. And I mean, you may be right that they went away with the notion that that meant anything appreciable, but for my part, I very much doubt it.
Well, Lord, what I would say at the present time is that we've now got another staging point on the spectrum, which we would submit is not necessarily helpful in practice.
All right. So what does more than merely trivial mean? Does it mean, in your submission, any appreciable effect on the capacity to do the three things that are listed in the section? Because if so, well, does it?
Well, my Lord, it is. Lord, I would answer it in a different way, because I think it's once you've identified the spectrum, it's for the jury to determine where on the spectrum the question of whether the impairment is substantial.
Well, supposing your jury comes back and says, we think there was some identifiable effect, but we're not quite sure whether it's trivial or not, but is that enough?
And of course, packed into that has got to be which cause significantly contributed to his behaviour.
Yes.
Which is the first thing the judge would necessarily need to.
Well, which order they do them in may vary from case to case, but I would be grateful if someone could think about what the answer is to the question. We think there was some identifiable effect. We've heard the psychiatrists. We think that they think, and we're not prepared to disagree, that there was some identifiable effect. Is that enough, Judge?
Well, my Lord, with respect, it seems, at any rate to me, that what we are getting involved in here is what does the judge say when the jury come back and say, Judge, are we sure? What does sure mean? There are many occasions in a criminal trial where you simply have to direct the jury and trust them. And the problem with criminal lawyers very often, and the problem with Glanville Williams used to say judges were lawyers who marked their own exam paper, right? But the problem sometimes is we can be a bit too precious about how juries approach these things. And one of the matters that comes out of the Law Commission's papers that preceded the 2009 Act was that the jury are entitled to approach this on a common sense basis and reach their conclusion. And as Professor Sir John Smith said, once you start telling juries what substantial means, you do get into the circularity of saying substantial means substantial. It's a matter for you.
As you must know when you say, you're preaching to the converted when you must know, as you must know when you tell me at least that you must trust juries to get on with it. But I still want to see what the answer to the question is. If you get the question that I've asked, it may be that the answer to the question is no. I shall simply repeat what I've said before.
Could I attempt an answer? As I understand your submission, what the judge must tell the jury is that the starting point is that it must be more than trivial. And if it's less than that, then the jury doesn't have to embark upon the question at all. But once that point is reached, it's then for the jury to decide, that staging post having been passed, whether it's substantial. So the answer to my Lord's question, I suggest, may be that when the jury come back and say, well, we're past the first staging post, but we want to know whether we've reached substantial, his answer is, it's up to you.
And
Well,
forgive me, sorry, I thought...
No. My Lord, may I say?
No, sorry, I think Lord Kerr hasn't finished.
No, I have finished, but I'd like an answer before another question.
And you haven't, sorry, you haven't, no.
Volley.
Well, what I was going to say, my Lord, is that goes straight back to Byrne. And what the Lord Chief Justice said in Byrne, it's a question of degree, and it's for the jury. And that decision in Byrne, it may be under the 1957 Act, but it is the foundation of this plea.
Well, I put it rather crudely, but in broad terms, do you accept what I put to you?
Yes, and it's a question of degree, and that is why they talk about the spectrum and the range and where it lies within that, but then identifying it to the jury, because you can use the other bookend, so to speak. The reason it's not total is because you're then into McNaughton insanity.
You don't need the other bookend, as far as I can see.
Well, the only
Well, you're
reason
into
you need
insanity on A and B, not on C.
Yes. You may need it, my Lord, because if it's total, an issue may arise as to whether it's insanity, not diminished responsibility.
That would be run as a...
Yes, I was wondering if I could just make that observation, that when one was talking about the practical reality, if you're directing a jury on diminished responsibility, then you're, in the first place, going to have to give them directions about murder and about manslaughter. You're in all likelihood, in diminished responsibility cases, it's run as an alternative to insanity, and directions on that. It's often run along with self-defense. So the practical reality is that for a jury to be expected to absorb and understand directions on these various difficult issues, there has to be some limit to how long you address them for, how much intellectual effort how much concentration really you require them to be able to exercise, and therefore a limit to the extent to which you can attempt to define every term you are using. And in this context, Parliament has said in the Act itself, impairment isn't enough. It has to be substantially impaired. That's a test Parliament has set, and it's a familiar English word.
My Lord, if I may say so, this is the basis upon which the case law proceeded in England. It is the basis upon which Lord Roger proceeded in Scotland in Galbraith, and it is the basis upon which the Law Commission proceeded in Scotland when it recommended the amendment of the law.
Yes, I can't remember if Lord Roger said this in Galbraith or not, but he often used to cite a Scottish appeal case called McPhillamy, where the point was made by Lord Justice Clerk that directions are not intended for the benefit of an appeal court. They're intended for the benefit of the jury, and therefore they have to be focused with the jury's needs in mind.
Lord, may I say that I respectfully agree, and with respect, there is a danger, looking at the Court of Appeal decision in this case, of resorting to the sort of linguistic philosophy that is perfectly at home in where semantics are important, and where the philosophy of language may require, as Peter Singer used to say, I think, that he spent so many mornings discussing with John Austin as to whether a shovel was a tool or an implement. That is not what we should be dealing with when we are directing juries on the test of substantial. And there is a limit. Lord, I ought to say that it's not frequently the case. It's not frequently the case that insanity is run with diminished responsibility. It appears as though insanity has become a defence only rarely
Right.
resorted to, but difficulties would arise.
I understand.
And of course, it is possible sometimes for
Yes.
the prosecution to assert you're actually insane,
Understand.
and
Then
then
you do have to.
the roles are reversed.
Then the upper level does have to be. I think Lord Tilson had a question.
I'm sorry, my lord.
No.
Can I come back to Lord Hughes's juror's question? We are persuaded that there was some abnormality of mind. Is that enough? Might the proper direction to the jury to be this? Members of the jury, in your judgment, is it more likely than not that the abnormality of mind made an impact on his ability to do A, B, or C, and that it contributed in a significant way to him doing what he did? If, members of the jury, you think your judgment is that it is more likely than not, then the defence succeeds. Would that be an appropriate response to the juror's question?
My lord, I would submit there are potential difficulties.
What's wrong with it?
My lord, the potential difficulties is immediately we are beginning to gloss the statutory language.
Are you?
Well, my lord...
What's being glossed?
Well, my lord, the impact on ability that's contributed in a significant way.
Well, you've got contributed in a significant way is the critical causative 1.1b, and impacted on ability is pretty akin to impaired ability. I mean, put it another way around. If it did have a real impact on his ability, and it contributed significantly, is the defence not available?
Well, my lord, the position we would submit is that it would still depend on the jury's assessment of the, as a matter of degree, whether they concluded it was substantially impaired.
You've just been preaching to us quite rightly that jurors don't want intellectualism, they want some practical help.
Yes.
And if, as a practical guide, the judge said to them, wouldn't matter in which order, has this affected, impaired his ability to do any of these things in a way which has significantly contributed to, that might be thought to be giving him a practical guide. Would it be wrong in law?
I'm not going to. I don't suggest, my lord, that would necessarily be wrong in law.
Well,
I'm not sure how it. I'm sorry. I'm not sure how it fits in. I'm not sure how it then fits in with 2.1.1c and b.
Yeah. Yes,
If I've understood it correctly, your lordship has put the two questions together of impairment and causation.
Both have to be overcome, but one can't look at one totally in disregard from the other. Now, we've seen that in the old context, the words real and appreciable were habitually used in contrast to minor or trivial.
Yes.
And I don't see why that can't sensibly be carried forward into this. Did it make a real impact? Has it contributed significantly to what he did? If there's a vice in that, if that doesn't reflect parliamentary intent, please help me. But it chimes with the usage of the language before the 2009 amendments.
I suppose under the 1957 Act, because the question, this I think was part of the the difficulty under the 1957 Act, or perceived to be, because it was the moral question. Then it was whereabouts on the range does the jury locate it? And our starting point is, first of all, we agree that we don't want to narrow the range, as it appears the Court of Appeal has done in this case. But when it comes to the application of where on the range the substantially impaired point is reached, then to give the jury the direction as to where it is on the spectrum, and that it's a matter for them as to whether it's substantially impaired, we would submit would meet the justice of the case and also give effect to Parliament's intention.
Could I just ask this, Mr. Perry? Do you agree with Mr. Etherington that this expression, substantially impaired, is one which has got to be applied not only by jurors but antecedently by the doctors?
Yes.
It has become the practice for them to express a view about it. And on the face of it, at least, the 2009 Act, which links impairment to specific capacities, underlines the likelihood that it's within psychiatric competence, even more than it was before.
Yes.
Well, in that event, the doctors need to know whether they need to know the answer to the question that I was hypothesizing that a jury might ask, don't they?
Well, my Lord, yes.
Because otherwise you're going to spend most of the trial cross-examining the doctor about what he means by substantially.
Well,
Professor Mackay vigorously agrees.
well, but my Lord, the problem was considered by the Law Commission when it was looking at these matters, and I think if I can, I've gone slightly out of my way, but I think if I may invite your Lordships and my Ladies' attention to the second volume of the Authorities at MS page 762, where there is the Law Commission Partial Defences to Murder. This was one of the early consultation papers, 173, in 2003. As the Court knows, this was looked at in considerable detail. And
Which paragraph?
It's 767,
Thank you.
Lord, underneath the heading Substantial Impairment. So this was when, with the Law Commission looking at it, and then going over the page, there's the 769, the little case law. I ought to first of all pick it up at 768, although the issue is not susceptible to any objective or scientific test. It's been the practice of psychiatrists to address it in their testimony and derive little assistance from the case law. Then 769, the impairment need not be total, but it must be more than trivial or minimal. Yeah. It's a question of fact. The judge may withdraw the issue for the jury, no evidence, etc. The Law Commission also looked at the role of expert witnesses in its later paper, which is Divider 45, which was a consultation paper, and it's MS 1114. And if I may just begin at 114, where there's reformulating the definition of, if I may just go to 1129. 1128 is where it begins. The role of the expert witness. And this is where the Law Commission is dealing with the And the point that is being made here is that although the role of the expert witness was important, at 6103, the judge should continue to make it clear that the ultimate question is for the jury. The jury here and takes a view on all the evidence. By way of contrast, the information available to the psychiatrist at the time may be much more limited. So, and also it goes on to talk about the limits on the medical examination that is being conducted. In its 2006 report, so we're getting much closer to the amendments to the legislation, the discussion at MS 1175, which is volume 3 divided 46, 1175, there's the definition under the heading, the definition of diminished responsibility. They say it should be modernised. Then 5110, it says nothing about what's involved in substantial impairment. Goes on at 51112 to deal with the definition that the Commission would adopt, and the importance being that it's modern and linked to modern psychiatry. At 5116, in law, it is sufficient that a condition is more than trivial. What matters is that it has the effect of substantially impairing D's capacities, and reference is given to Lloyd. It follows that alongside the familiar psychotic orders, etc., neurotic orders and violence, and then 5117, we believe the provisions make clearer the relationship between the role of the expert and the role of the jury. It's for the experts to offer an opinion on whether the defendant was suffering from an abnormality, etc., and whether the abnormality had an impact on D's capacities, 5118. It's then for the jury to say whether in the light of that and all the other relevant evidence, they regard the relevant capacities of the defendant to have been substantially impaired. And then there's evidence from the Royal College of Psychiatrists and caution or concern is expressed by the professionals as to in effect, dominating the trial process. And that is why, my Lord, we've made clear in our written submission that there is an important public confidence point here in relation to the way these trials are conducted and also the Brennan-type argument. Because if it is perceived that it's the lawyers and the doctors who decide these cases and not juries, then that will be a very significant change from what was the position under the 1957 Act, and one that we would say was not intended by Parliament. That simply was not the intention, right. That the lawyers and the medical experts, important though they are, should dominate the trial process and in effect decide these cases and marginalise the jury's involvement.
Are you saying, therefore, that the medical experts should not express a view on whether it was substantial or not?
No, they have to, my Lord, because
right.
that's the way the section is structured.
Well, I understand that, but if that's right, then how do you deal with Lord Hughes's point?
But, Lord, the way that you deal with it, I don't think I can really improve on Professor Ormrod's analysis of this, because he, although Lord Justice Davis relied on Professor Ormrod's paper when deciding the case of Brennan, Professor Ormrod is critical of the outcome of Brennan. And in the extract that has been provided to the court this morning, it's at page 619.
Thank you.
The role of the expert and the jury. And if I may just summarise, because the court has it.
We'll read it.
The point that is being made is that although the role of the experts has increased under the reformulated provision, it is still ultimately a jury question, because the question of the weight you attach to the expert evidence is a matter of credibility, for example. There may be other issues about the evaluation of the other evidence in the case. The point, my lord, I suppose, is really this. The expert expresses his view on the basis of his analysis of the patient. The jury express their view on the basis of the evidence in the case as a whole. And that may make a significant difference. Take this case as an example. The judge...
Well, yes, I understand that, but what you're effectively saying is if the jury may say we accept all the evidence the psychiatrist gives, but we disagree with his view on the meaning of the word substantially. We could have that, could you?
My lord, I would put it on the basis that we do not accept the conclusion that there was a substantial impairment because there is a basis for us rejecting that conclusion.
Well, no, but I mean, could they say we quite accept all his medical evidence and his opinions, but we don't think, even though he thinks it does, it amounts to substantial?
The jury could say that in the end, because it is ultimately the jury issue.
So, therefore, it's almost inevitable in a number of cases that expert witnesses will be cross-examined as to what they mean by substantial.
But Lord, yes, and as was the position as we saw under the old law, and as we saw in the Ramchurn case, where there was cross-examination.
Yes, thank you. I think Lord Reid had that.
Well, I was just going to say that they'll also be cross-examined about the factual basis for the opinion, the medical opinion they're expressing. And that will usually be based on taking a history from the defendant. They may have information from police statements or the like, but at the end of the day, it's the jury who will hear, no doubt, conflicting accounts about what actually happened, and will have to sort out for themselves what they are satisfied happened. And having done that, that may then affect the view they take of the opinions expressed by the psychiatrists.
I respectfully agree, my lord. Rather, as in this case, where the judge described as a critical issue whether the appellant had been truthful with his clinicians, because he said that it was his partner who'd been violent towards him and that he had never retaliated. Now, to be fair to the doctors, they were asked about this, and they said, well, in our view, it doesn't really make any difference. But that raises a real question about credibility and what else might be in play for the jury's consideration. And the other important matter that we would submit is these cases tend not to be over in a day. The jury is sitting there absorbing the atmosphere and the evidence. Usually, as in this case, I think this case took something like 10 days, maybe in 12, I can't remember. But that is an important consideration, because the jury have a real feel for the case, which perhaps the printed page does not convey, and that is why these questions we would submit are in fact left to the jury. My lord, I was, if I may, may I just make these additional submissions? First of all, we would submit that the decision in Ramchurn is correct and accurately stated the law under Section 2 in its original form. And we also submit that it accurately continues to reflect the law under the section in its amended form. And this also appears to be the view of Professor Ormrod in the extract from Smith and Hogan, to which we've drawn the court's attention. Ramchurn, there are three key points. First of all, the word substantial is a descriptive word of degree, and Lord Judge made it clear that the spectrum of possibility lies along the range from what I've said. The obligation on the trial judge is to convey to the jury the plain meaning of the statute, no more, no less. We would submit that would be done, as in this case, by using the language of the statute. And the third key point is, provided the language used by the judge does not exaggerate the burden or improvise some other test, then there can be no complaint. And in relation to, I've made references to Galbraith and the Scottish Law Commission. Without turning to them, may I just give your lordships and my lady the references? The decision in Galbraith is at volume 2, divider 22, MS, page 490.
Thank you.
And in particular, see Lord Roger at paragraph 50, at the conclusion of his discussion of diminished responsibility, where he talks about substantial impairment and did not seek to gloss the requirement at all. The Scottish Law Commission, if I may just take the court to this, it's volume 3, divider 48, and the MS page is 1209. It's the 2004 report.
Yes.
But the relevant paragraph is 315 at page MS 1216.
Yes, thank you.
Where the court can see the Law Commission recommended that the test should be reformulated to conform to the Galbraith criteria.
Yes.
They agreed. The key expressions: abnormality of mind, substantial impairment, ability to determine, having the context of the plea, relatively clear meanings, and are generally understood by those persons who are called upon to apply the test. And then the court can see the recommendation was simply to have substantially impaired. No attempt to. Then the Crown Court bench book, I can simply give the court the references because it was the approach adopted by the Judicial Studies Board and latterly the Judicial College. Volume 2, divider 24, for the March 2010 edition, MS 529. C in particular, MS 531 and MS 541.
Yes.
The Crown Court Bench Book, October 2011, is Volume 2, Divider 25, MS 544 to 545. Again, they were using the sort of Ramchurn spectrum. And then the Crown Court Compendium, if I may just go to this, Volume 2, Divider 26 at MS 578.
Thank you.
Because this is as a result of the decision in Golds. May I just make two observations? First of all, we would invite the court to compare what appears at 578 in terms of clarity with what appeared in the earlier judicial directions. And then if the court goes
Is that to compare it favourably or unfavourably?
Sorry, I'm sorry.
Comparing it favourably or unfavourably?
We would say unfavourably, my lord. This is more complicated.
Yes, I understand.
Because of the no man's land point.
No,
So which paragraph is it? You've given us page 578.
It's paragraph 8
Paragraph
to
10.
10.
Paragraph 10.
Yep, thank you.
And then in the example that is then given at 581,
Yep. Yes.
It doesn't seem actually to correspond to what is said earlier,
Right.
because it says substantially means that the impairment need not be total, but must be more than merely trivial. So, again, the sort of semantic difficulties, and then it goes on to deal with the contributory factor. So we would, just by way of example.
We're comparing paragraph 10 of this document unfavourably in your submission with which precise paragraph would you recommend we looked at?
Yes, and when you look
in tab 25 or 24, which one should we?
Well,
no doubt it's both, but I mean, where
they're both at 581 is difficult.
Understand.
And, my Lord, may I just...
So which was the paragraph you were suggesting was better?
If you go to MS page 541, for example,
in tab
24. This is from the the Crown Court Bench Book, March 2010. And it deals with substantial impairment. Actually, it's in the context of alcohol, that right. Particular one. But it means less than total and more than trivial. Where you draw the line is for your good judgment, and that's also the position at 537 in this bundle, where you draw the line under substantial impairment. That was also the position in 2011, and at MS page 551, for example, this is under the amended law. 551.
Yes.
This is under the amended law in 2011. The court will see the illustrated route to verdict that begins at 550, and question 4. Did D's abnormality of mental functioning substantially impair his ability to form rational judgment or to exercise self-control, or both? See note 1. A substantial impairment is less than total impairment, but more than trivial or insignificant.
But basically what you're saying is that the Judge DeVoe directions approved in the directions he gave, which was approved by in the Court of Appeal, are more satisfactory than what they've said in Gold.
Yes. Yes, thank you very much, my Lord.
Thank you.
We've set out in our printed case what we say in relation to the decision in Byrne and Simcox and
yes.
also Lloyd. The point, and Ramcham for that matter, the point about the degree. I've dealt with the Law Commission papers.
Yes.
And may I then just adopt what appears in our written case, and just invite the court's attention to one final matter on this aspect of the case. There is some academic criticism of the Court of Appeal in relation to the no man's land point, and it's from Professors Mitchell and Mackay. See Volume 2, Divider 31, MS, page 599 to 601.
Thank you.
And may I, without reading it,
yes.
Merely draw attention to it, because the point that is being made is the semantic difficulty point.
Yes, I see.
And the meaning was, in fact, clear, and it didn't need to be narrowed. There was no reason to think Parliament...
So really it's adopting your point that Lloyd was satisfactory and Gold has muddied the water.
Yes, thank you very much, my Lord. In relation to whether the...
Sorry, that's Professor Mackay, it's not...
I thought it was...
No.
It's 599.
Mitchell.
Mitchell.
Sorry, Mitchell. 599. Got it.
599.
Sorry. The previous one was the case note by Professor Mackay.
Yeah, this is Professor...
This is, yes.
And Mackay. And we would submit that, that there is some force in what is said there. In relation to whether the jury need to be directed on the meaning of substantial. We agree with the Court of Appeal. We would submit that there can be no objection to the jury being directed in accordance with the words used in the section.
Well, does that mean that you believe that the jury should be directed?
They should simply be directed, my Lord, as they were directed in this case by the judge in relation to...
In other words, they don't get any direction unless they ask for it?
Unless they ask for it, because they're being told, as Professor Smith said, to employ an ordinary English word which it's for them to apply, and if they need assistance on the point, they can ask for it. And if they were to seek assistance, then we would submit, as I think Professor Ormrod suggests, then the Ramchurn direction would be the appropriate direction.
But
So,
how much of Professors Mitchell and Mackay's comments are you adopting?
but my Lord, the comments in relation to the fact that the purported narrowing of the defence by the Court of Appeal in Golds was not justified on the basis of the construction of the section, nor on the earlier authorities.
Yes. Well, I mean, it'd be helpful to have your comment on what they say, because the two professors come with very considerable experience in this area. Page 600, foot of column 1 and onto the top of column 2.
The clinical guidance point. my Lord.
Yes,
Yes.
And how there's some relevance here to what point raised by Lord Hughes, that we've got to try and give clarity to the psychiatrist now that the point has been raised, however necessary or unnecessary it may have been. And then we have their observations at the first full paragraph, right-hand column 600. I'd be interested to know whether you support that.
Well, but my Lord, to the extent that the professors are making the point that this is a contextual matter with shades of meaning, but the point I think is also being made here. I don't think it's disputed here that in the end the matter is a jury question.
Yeah, but if they are wanting guidance, I mean, the view they put forward in that paragraph, we see it. It would be undesirable to get bogged down in semantics, but worth noting, one of the dictionary meanings of substantial is real and tangible rather than imaginary. Significant means having an unstated meaning, indicative of something, important enough to merit attention. Appreciable similarly implies large or important enough to be noticed. None of these indicate the purpose of section 2.1, that the impairment must be further along the spectrum than minimal. They're capable of being so construed, but doesn't necessarily automatically follow. That's the view that they're canvassing, and they criticise Golds for limiting it. What do you say about their approach, that the words significant and substantial don't carry greater weight than their suggested meaning?
It all depends which dictionary definition of substantial you take.
But
that's the problem.
Yes,
I mean, you've commended the article to us. I just want to. There's a lot in it. Be clear in my own mind whether how much of it you're going along with.
But, my Lord, what I go along with is this. I agree with the point they make in relation to there isn't this border before you get into substantial, because that border seems to us to be impossible to identify or explain to a jury in any sensible way. However, the professors do appear to accept that this is a question of degree and there is a spectrum. What they're really although they come on to criticise the fact that there isn't more elucidation, what they are really criticising in this article is the narrowing of the spectrum. That's the point, and we respectfully agree, in fairness, to accuse persons who want to rely on this defence. But we do not accept that once the experts have opined on the matter, then the role of the jury is simply to accept what the experts have said, or that once the experts have said something is substantial, it necessarily follows that the jury are bound to agree with it.
Mr. Perry, how much longer do you expect to be?
My Lord, I'm very sorry. I hope I can finish in just a couple of minutes, my Lord, or perhaps 5 minutes, if that's...
I think we should. It's simply a question of whether we adjourn now or not, but I think in light of that we should complete the hearing this morning.
Thank you very much.
Unless that puts anyone in difficulty. Yeah,
but Lord, we've made our submission in relation to the fact that no direction is in fact necessary. The cases where no direction was given include Mitchell, which is Volume 1, Divider 14, MS page 419, and Baker, Volume 1, Divider 15, MS page 421. And we also adopt what is said by Professor Ormrod in the extract that has been put before the court this morning. And that really encapsulates, I submit, our argument. My Lord, may I just say something finally about the Brennan matter? The first matter is the court's jurisdiction, because we, for our part, would certainly not want to take any technical jurisdictional point. And certainly under the old procedure, which we would submit still prevails, Attorney General and Gallagher, for example, going back to the early 1960s, it has never been suggested that once a certified question is before the court, that an accused person is debarred from raising a point that might be in their favour if it turns out to be in the interests of justice. And I simply raise that point. I don't accept that there's a Brennan issue at all in this case for the reasons we've set out in our written submissions. And also, on the Brennan aspect of the case, it is also significant to note the role played by the causative question, because we would submit that makes it more difficult for a judge to remove the issue of murder-manslaughter from the jury, because the question of whether it was a significant contributing factor in causing the defendant to carry out the conduct is a factual issue which is preeminently for the jury to determine. But there was in this case other evidence in relation to all the background and the previous incidents which could have led the jury properly and logically, as the judge put it, to reject the opinions that had been given by the experts, no matter how eminent those experts were. So we say that no Brennan issue actually arises. But, my Lord, for those and the reasons we've set out in our written submissions...
Can I just ask you one thing? In relation to Brennan, you say there's no issue in this case, but is there anything in Brennan than actually the ordinary, straightforward principles? I mean, one doesn't want to erect, unless it's absolutely necessary in this area of the law, some new doctrine, because our experiments in doing so have not generally been successful. But is there anything we call it the Brennan principle, but is there anything new in it?
Well, there isn't anything new in it. In our written submissions, we've said it's no more than an application of ordinary principles. There was no evidence. My Lord, may I just say in relation to that, Professor Ormrod criticises the decision on this basis, that once there was evidence of planning of this incident, that was really for the jury to evaluate.
But that is surely just the application to the particular circumstances of ordinary principles.
Yes.
It's not a new principle. That's,
Yes.
At the moment, I find it extraordinarily difficult to see what principle there is in Brennan. It's an application of well-established principles to this particular kind of area.
Yes,
I think, for my part, I find these developments of sort of new principles, unless there's some real reason to do so, is to be avoided.
Yeah. My Lord, the only thing I would say is that it is arguable that the decision should have gone the other way.
Of course, like any decision of the application of the law to the facts.
Yes. But certainly we say it's a long way from the facts of this case, and you wouldn't, on analysis of this case, reach a conclusion that there was no basis for the case of murder to be left to the jury, or that the conviction is unsafe as a result of it being left. But those are the submissions that we would make resisting the appeal.
Thank you very much, Mr. Perry. Mr. Little.
I won't follow.
Thank you very much indeed. Mr. Etherington.
I don't really have any substantive reply, because the issues are clearly before the court. Save that, we do not feel the test that the real impact test, if I may summarise it in that way, does do any injury to the statute and is clear, and by combining the two sections together, deals with a number of the objections that we made in respect of substantial impairment.
Thank you very much. Well, Mr. Etherington and Mr. Perry, thank you very much for oral submissions, and thank you very much for all those involved in the written submissions on the law. And what we appreciate is on the facts of a very tragic case. We will consider our decision and make it available in due course.
Thank you.
Thank you very much indeed.